Good morning, good afternoon, everyone. We're just letting a few people into the chat, so we'll probably give it another 30 seconds or so, and then we'll get started. Okay, let's go. All right, good morning, good afternoon, everyone. Many thanks for joining today. My name is Alison Macbeth. I am the Southeast Asia Coordinator at the Global Initiative, and I will be moderating today's panel on species victim impact statements. As I'm sure many of you are aware, wildlife crimes are regularly perceived as mere technical breaches of conservation regulations rather than as serious criminal offences that directly impact the species and the ecosystems from which they were removed. When such crimes have been prosecuted in court, the animal victims are often marginalised from consideration in sentencing decisions, as jurisdictions largely recognise animals only as legal property to be either confiscated or returned to their owners. Academics and civil society organisations, working largely independently of each other, have approached this problem by adapting victim impact statements for use in environmental crimes. As the animals in question are at a fundamental disadvantage because of their inability to speak, these species victim impact statements are designed to give them a similar voice to help inform presiding judges and the harm caused by wildlife and environmental crimes. This is an innovative approach that introduces ecocentric concerns into anthropocentric legal systems. It has grown into an effective body of practice, leading to increased sentences for environmental crimes in countries where academics and civil society organisations promoting this tactic are operating, including Hong Kong, South Africa, and Zambia. The success of these countries prove that the concept can be scaled up to increase the number of jurisdictions using these tools and can help to increase the effectiveness of the judiciary in deterring perpetrators of environmental crimes. In January of this year, the GI-TOC published a community tool report based on the experience of those who have successfully used species victim impact statements in the jurisdictions in which they operate. And we are very lucky to have them on the panel today. The co-author of the report, Professor Amanda Whitford, created the Hong Kong University Impact Statement Initiative in 2015 and has been a leading advocate for their use within multiple jurisdictions. The concept has also been developed for use in Southern Africa by the non-profit organisation Endangered Wildlife Trust, which developed its own project in 2018 with extensive research and engagements with experts from across the region. The Wildlife and Law Project Manager for EWT, Ashley Dorr, also joins us on the panel. We're also very lucky to have Professor Ray Jansen, who is a pangolin species expert and a founding member and initial Africa chair on the International Union for the Conservation of Nature Species Survival Commission, pangolin specialist group in South Africa. Ray has been heavily involved in the response to pangolin trafficking in South Africa, which has included acting as an agent in upwards of 100 intelligence-driven police operations, recovering pangolins from smuggling networks, and presenting testimony in more than 30 court cases. Finally, I would like to welcome Diana and Edward from the civil society organisation Wildlife Crime Prevention, working in Zambia. In 2017, WCP started a project to support the effective prosecution and appropriate sentencing of wildlife crime offences, which included the development and sentencing guidelines for species victim impact statements to be used by public prosecutors at trial and in sentencing submissions. Diana is an advocate for the Superior Court of Zambia and the Programme Manager of WCP's Wildlife Criminal Justice Programme, and Edward is a legal officer at WCP and an advocate of the Court of Appeal of Zambia. Amanda, Ashley, Ray, Edward, and Diana, many thanks for taking the time out of your busy schedules to discuss your work with us today. Just a little bit of housekeeping. If you would like to ask a question of the panel, please use the Q&A function. One of the panelists, if it's directed at them, will try and answer it. Otherwise, we can bring it up at the end of the discussion. So, Amanda, if I may put the first question to you to get the conversation started. You founded the Hong Kong University Victim Impact Statement Initiative in 2015. Can you please tell us where the idea came from and why these impact statements are important tools in the response to environmental crime?
Sure, thanks very much. I started this because I was very concerned about sentences for wildlife crime. Globally, there is concern about lenient sentencing in wildlife crime. Hong Kong is a wildlife trading hub. And I was aware as a criminal lawyer, I'm in practice as well as working at the University of Hong Kong, of very, very lenient sentences coming out of the courts. And it was clear to me that the judges weren't receiving appropriate information about the impact of wildlife crime. And so they were treating this as a regulatory offense, as you suggested in the introduction. And I decided that they needed better information, and that information needs to come from prosecutors. So obviously it needed to be an educational tool for prosecutors and judges. And I got the idea actually from Scotland, because in 2015, the Scottish government commissioned a review of wildlife penalties. And as part of that review, they found out that on an ad hoc basis, prosecutors in Scotland were receiving ecological statements from Scottish national heritage, and they were using them to prosecute local poaching cases. Birds and such. And so I thought, well, why can't we use that for smuggling or for international trade? And so I developed the project together with ecological experts, because I'm a lawyer, but I'm not a scientist, and you definitely need scientific input into a good victim impact statement. So I developed the project with ecologists working out of the School of Biological Sciences at the University of Hong Kong in their conservation forensics lab. And initially we developed only 30, but it's now grown into a body of species victim impact statements for over 150 species that are widely in trade across Asia. And we use them to provide information to prosecutors, to our agricultural, fisheries and conservation department when they're preparing cases and investigating cases. And we also use them to train the judiciary of Hong Kong through the Judicial Institute here in Hong Kong. So they have an interest in understanding wildlife crime better, because the penalties for wildlife crime were raised in Hong Kong in 2018. And judges, of course, when penalties are raised, always want to know more about the crime so that they can write a good sentence and write a judgment that will be upheld on appeal. So we use it as a judicial training tool as well. And now that's expanded beyond Hong Kong's borders to China and to 10 other countries across Southeast Asia.
Thank you very much, Amanda. Did you say the value of species victim impact statements come from their ability to introduce information to a judge, so they have the relevant information to help inform their sentencing decisions? Can you explain how these statements are introduced to the courts in Hong Kong and how effective this has been since the start of the initiative?
Sure. Well, we have a victim charter in Hong Kong, but like most of the world, it's for humans. So we don't hand them up as victim impact statements. That's what we call them, but we use them really as an educational tool for preparing cases and presenting cases. So the way that they get into the court is the prosecutor might use them in their opening statement. They might use them in cross-examination of a witness in the rare cases that are contested trials. Most of them are pleas. They might use them in a summary of facts to explain to the judge what happened in the case and why the crime should be treated seriously. And they might even use them as a tool of negotiation with the defense, as far as trying to get an agreement as to what the value of the species is, both in monetary terms and in ecological terms. So they're a way of empowering the prosecutors to better present the case to the courts, and they're a way of educating the judiciary. So we've been looking, of course, at the cases that come out of the Hong Kong judiciary since we started the project. We started training the judges in 2018. And what we see are very regularly parts of the species victim impact statement being quoted in the judgment. And the sentences have risen an extraordinary amount as a result of judges having this information. Judges are thirsty for this information. We know this from research from UNODC, from Eurojust, that's the EU Judicial Cooperation Unit, and also from traffic, that judges want information about wildlife crime so they can apply their judgments, so they can apply their reasoning to their judgments more effectively. So judges in Hong Kong, we can see in some cases for the less charismatic species where the sentences were very low, by which I mean turtles or other animals that we don't always think about, they've been increased by up to 2,000% since the judges started to pay attention to the species victim impact statements. And they've even been used in our Court of Appeal, where the prosecutors have upheld very long sentences on appeal by referring back to the species victim impact statement information, which might be presented on an appeal through an expert witness statement.
Thank you very much. That's very impressive, the large percentage figures of the increase. Actually, turning to you and the work you've done in Southern Africa, given the scale of wildlife crimes in the region, could you explain why impact statements are so important and what they have been, and what have been some of the key lessons learned from the process you undertook to develop these statements for Southern Africa?
Sure, thanks, Alistair. I think it follows really logically to what Amanda has just said now, is that the voice of harmed species, of harmed communities, of harmed people really haven't been coming through in prosecutions. We tend to look at the legal violation as opposed to the harm that results from the legal violation. And in 2018, we were introduced by Amanda Littlewood from the United Kingdom to the role of victim impact statements or impact statements, and really regarded them as a very valuable tool that we could use to create a platform for victims of these crimes to be heard in criminal prosecutions. And I'm representing a project that my colleague was really the leader of. Her name was Karuna, or is Karuna Brevet, and she was with the Endangered Wildlife Trust for several years, operating this project that was funded by USAID. And just to share some information with colleagues who are interested in developing this within their own jurisdictions. Like Amanda said, the process in Hong Kong may be fundamentally different from the process in other jurisdictions. So what we would recommend as a starting point is to first do foundational research, understand how your criminal framework operates, and how impact statements or expert statements can be used in criminal proceedings. Our context is quite different from that in Hong Kong, in that we adduce evidence through expert testimony, and impact statements are a form that we do that, but then there is also a process of cross-examining that expert in court. So that would be the first context or lesson that we would share is understand the framework that you're operating in, understand the laws that you're operating in, and try and expand it beyond the cute and fluffies, as Amanda also said. Focus on all species that are impacted. And sometimes it's the less charismatic species that are actually in the most decline, and ones that we need to be focusing on from a justice perspective. Karuna did extensive research in the beginning and had engaged with experts like Amanda, and also did incredible foundational and doctrinal research, as well as engaging with subject matter experts like Ray and other experts in Southern Africa from a species perspective. And what she then did, so that there's a constant approach or uniform approach, is developed a template for impact statements, so that there's a consistent flow of information, but it's informed by species experts. And that would probably be the second lesson that I would share, is have a collaborative approach in the methods that one follows. What we then did is worked with our experts. They then populated these templates, and we then shared them with over 100 prosecutors from Southern Africa. And that is perhaps the third lesson that I would share, is take a regional approach where you can. Illegal wildlife trade doesn't pay too much mind to borders, and we shouldn't either in the approaches that we take to address them. So we would see very similar methodologies from our neighbors in Mozambique to what we're seeing in South Africa. And what you would like is, while your impact statements need to be country specific, the information and the impacts and the methodologies should be consistent across the region, so that you also have a consistent prosecution process across the region as well. So I think in summary, foundational research is critical. And that applies both to your jurisdiction or project area, but also take global lessons as well. If you can take a regional approach, do take a regional approach, but the outcomes also do need to be country specific to be adduced into criminal proceedings, which are inherently very legal. And then collaboration is key. And also one thing that we did learn is take the time that is needed to sensitize both your prosecutors and your species experts. What we have found is there's sometimes a bit of a fear of legal processes. So we did have to work quite actively with species experts who haven't been giving expert testimony in courts to sensitize them to the process and what would be expected from them if they draft these statements and are ultimately called as an expert witness. Thank you.
Thank you very much. That's a perfect segue preparing my next question for Ray. But staying in Southern Africa, so Ray, you, as I mentioned in the introduction, you've had considerable experience in the response to pangolin trafficking in South Africa, and you have presented testimony in aggravation in more than 30 court cases where suspects were convicted of pangolin trafficking. Can you explain the process of giving testimony in court and how it supports the written impact statements that are entered on the docket?
Yeah, thanks very much, Alistair, and good morning, good afternoon, and possibly good evening to some folks around the world. Yeah, there are three big things towards species-specific conservation, working with pangolins in particular. The one is to get the poor animal out the trade and arrest the guys. The second is the hospital and rehabilitation, and probably the third, and often the most arduous, is the court proceedings that can go on for a number of years, even up to 3 years, with a recent case where they contest being found guilty or being guilty of an offense. So I try to present myself at every single court case in person because Africa is an interesting place. You can develop the most wonderful species victim impact statement, but it sits in the docket, but it's never read into the court proceedings. And aligned with that, the prosecutors are often not familiar with the species, in particular species such as pangolin, which are unobtrusive and only known in culture and often not seen, but highly endangered. And then it's not read into court proceedings. So the victim impact statement may be there, but it may not be taken notice of. And so I try and appear in every single court in the country, assisting the prosecutor, and then I tailor every single impact statement to the case. In other words, I include the case number, I make it very personalized, who the suspects were, what transpired, and then give a synopsis of the trade of the greater species, in other words, the order, the Foliodota in Africa, and how it supplies the global trade now in supplying Asia. And then I refine it down to the specific country, for example, where I am, South Africa, and the specific case. So you make it very personalized, and the prosecution and the court seem to take note of that, that it's not just a piece of paper, and although nationally, as Ashley and Amanda have said, it's really important to have something on a template. I try and personalize it, and I did this for the first time in a very rural court east of a city, Polokwane. The court's name was Manquen, and an illegal immigrant we arrested with a pangolin near there was on trial, and nobody, not a single person, had spent any time in jail as a result of pangolin trafficking, which is the most trafficked mammal globally currently. She got so worked up, she blamed him for poaching all the rhinos as well, for AIDS, for everything. And he did, for the first time, he did a sentence of 3 years. And subsequently to that, we've had 3 10-year sentences last year, in accordance with our National Environmental Management Biodiversity Act of 2004, being implemented almost to its full extent. And now we've also added cruelty to animals to the victim impact statement. And on the 1st of March this year, 3 suspects were found guilty and are serving 4 years for cruelty alone, 8 years for trafficking in pangolins. So coming from me, and a take-home lesson is to try and personalize it. I know it takes a lot of work, often in rural courts, a lot of traveling, expenses, etc., but it's really paid dividends. And the knock-on effect is that the traffickers are really scared now to start trafficking in the species. I'll give you an example, a recent one on Friday, this last Friday now past. The traffickers just pitched up to the chap's farm and dropped off the pangolin in a sack and then drove away and said they'll come back for the money later. That we've been targeting them for about a week. They really are scared of the sentences that are being handed out. And I think the importance of being there in person, along with a modeled victim impact statement with brand new statistics, gives the court an insight, an up-to-date insight of the reality of trading in specific species, as is my case.
Thank you very much, Ray. Got a quick follow-up question for you, but there's a few questions coming through in the Q&A. So if anyone would like to have a stab at answering, otherwise I think we can pick it up after the Q&A session at the end. But I invite everyone watching, please put your questions to the panel. It's a very good panel, with a lot of experience in this area. It'd be good to find the views or questions to answer. Staying with you, Ray, just quickly. When we talked to you, about a year ago, we talked about the importance of impact statements needing to be people aware of them. The issue of sentences being increased, people have to be aware that this is now there's higher risk of participating in the crime and environmental crime. And you've been a leading force in South Africa, bringing public attention to the harms of the pangolin trade, and you've appeared on multiple TV and radio broadcasts. How important is media coverage and the success of impact statements, and is that really starting to move the dial?
Yeah, thanks, Alistair. On social media, I often get a lot of more acknowledgement for the war, which is typically of human nature. They want to see the bust and people arrested, and it's actually the ugly part of it. And I get less responses of when I post sentencing. That's just human nature. But in every single one of the intelligence operations I've been involved in, every single one of them has come from a member of public that's either heard of a particular species in trouble or heard of people being sentenced as a result of a transgression of with an endangered species. And they didn't know that certain species, whether they're loggerhead turtles or tortoises or abalone or pangolins or whatever the small little species may be, actually has an act written for it. Sometimes it's a generalistic act. For example, in South Africa, we've got the Threatened or Protected Species Act, the TOPS Act, where certain species are listed. And if you're caught in possession or trafficking illegally in the species, this is what you may be sentenced to. Not only do the public are not aware of such an act, but the transgressors or even the courts are not aware of such an act. And this is often conveyed by members of the public through social media. So social media has become the point of the sword in certain species, in particular pangolin trafficking, which they can just be popped into a rucksack, similar to rhino horn into a rucksack, but it's an entire organism, a living organism, often in Southern Africa, that's popped into a rucksack, and often trafficked in communities and made awareness in communities. Where can I sell this animal? For how much can I sell this animal? And people become aware by reading social media, whether it's Facebook, Instagram, X. People, even the beggars on the side of the road, have got their cell phone hooked up, well, not in South Africa yet, but there's certainly other countries to platforms such as Starlink, where the internet is freely available. So public awareness, both through not only catching culprits or suspects, but sentencing, is really important as a global awareness campaign.
Thank you so much. Let's move towards Diana. So Diana, quick question for you. Wildlife crime prevention has been working with the Zambian National Prosecution Authority to develop guidelines that can be used by public prosecutors in the trial and sentencing submissions for wildlife crimes. Can you explain how the process works in Zambia and the success in disrupting wildlife trade syndicates?
Thank you, Alistair. So with the Zambian system, initially the plan was to develop sentencing guidelines for magistrates and judges. However, because our act has minimum sentences, so for protected prescribed trophy, you would have, for first offenders, that's a 5-year to 10-year imprisonment, and for second offenders, that's 7 to 15 years imprisonment. So the next option was to develop sentencing guidelines that will provide information, obviously, to the magistrates or to the judges to be comfortable to sentence beyond the minimum, because mostly you'd find the sentences that would come out would be the minimum. A number of accused persons tried for prescribed or protected trophy would be sentenced to 5 years imprisonment. So we have been working over the last years with the National Prosecution Authority and the Department of National Parks to come up with the sentencing guidelines. And as the rest of the panelists have said, these sentencing guidelines for each case, they must be tailored to suit a particular case. They must be personalized to a particular case, depending on what the circumstances are. So for example, you would have a case that is coming from a private ranch, that the impact statement in relation to a crime committed in a private ranch or somewhere in a national park may have a different facts to it and different information that will be required, and will have different witnesses brought before the courts of law. So in the use of impact statements to disrupt syndicates, we are still in our infancy stage, of course, in making use of impact statements. But I would say over the years, we have utilized the use of impact statements by producing them through aggravating circumstance evidence. So you would have a prosecution witness in testifying, speaking to the aggravating circumstances of that particular offense. And then when an expert comes in to testify to the identification of the species, they'll also speak to what the disruption has been caused by the acts of the suspect. So for example, if you find that it's an pangolin trade, what negative effects has it had on the population of pangolins, and or what negative effects has it had on the population of elephants? And maybe if it was a bull that was poached, what effect does that have on the herd that is left behind? So when we look at the use of impact statements in disrupting criminal syndicates, not only will a suspect convicted to a higher sentence be removed from actively engaging in illegal wildlife trade, this also negatively affects the syndicate in the economical sense, because you would find that they would have to pay a more higher fine if it's a finable offense. If it's a government trophy involved, they would have to pay a higher fine depending on what information has been provided for the courts and what would then motivate the courts to sentence this particular individual to a higher sentence. And so that would mean losing out on finances by the syndicate. In addition, law enforcement agencies would be provided with insight into what the effect has been of the actions of the syndicate, and they are able to follow up with financial investigations. So for example, if there's been a large seizure of ivory or cat skins, this then points to a syndicate that has been over a long period of time, building up a stockpile and deriving a significant financial benefit from wildlife trade. And therefore, once this has been brought to their attention through the production of the impact statement and what the effect that has been on. So within Zambia, the focus is not only on the populations of wildlife or on the ecological effects, it's also on the economic effects. What has the government lost out on because of this poaching incident or these poaching acts that have happened? So this helps with the disruption. And I think, as Ray pointed out, the media coverage that comes with higher sentences discourages the low-level actors who are mostly the targets by more complex syndicates to contribute towards the stockpile. So once those are discouraged from being the ones to provide trophies, wildlife trophies to the stockpile, you will have an opportunity for the people that are funding these activities coming out. Instead of sending the low-level actors, they would have to be forced to come out and commit the offenses, and it will now be easier for law enforcement agencies to have access to them, as opposed to arresting the low-level actors. So I think that is something that legal systems, that is something that law enforcement agencies can take advantage of, in addition to raising awareness among the adjudicators, even as they pass sentences. It will also provide a basis for law enforcement agencies to look further into the financial gains that are being gained by the financial gains of the syndicates, and being able to have a basis to disrupt the trade by disrupting the syndicates. Thank you.
Thank you very much. It's very interesting. Staying in Zambia, Edward, in the past, there's been backlash against wildlife legislation in Zambia, with some complaining that it protects wildlife over human interests. Can you explain how the impact statements have considered the socioeconomic situation and what other challenges and limitations associated with their use in wildlife criminal justice?
All right, thank you so much. Please bear with me if my audio and internet is a bit bad, but I'm based right in Swift National Park, so please let me know if my audio is not very good. But to touch on the challenges associated with victim impact statements as they relate to wildlife in a Zambian perspective. First and foremost, there's limited understanding of victim impact statements generally, not just in relation to illegal wildlife trade, but also as it relates to other social vices. So if you narrow it down to wildlife itself, presenting a victim impact statement for a wildlife case becomes the justice actors, the prosecutors, the law enforcement, they don't understand victim impact statements per se, even as they relate to wildlife. As other colleagues have already mentioned, there's been moves towards coming up with standardized methods or templates which can be used for various species and presentation of victim impact statements for these various species. Then also you have to also be aware of the fact that wildlife offenses are considered to be victimless amongst most members of society. So not only the justice actors themselves, but including society in general, perceive wildlife offenses to be victimless. So even pushing in an agenda of a victim impact statement becomes complicated, because questions arise as to who is the victim. Is it the society that is the victim, or is it the wildlife species itself that is the victim? So all those issues arise amongst the challenges. Then also, like earlier mentioned by other panelists, expertise in the field of conservation are few, especially in Zambia. There's not so many experts that can come to court and testify on specific species and the impact of that specific offense on that particular species. So, for instance, in an event that the offense is in relation to a pangolin, then you would need an expert on a pangolin to come and speak to the impact that the offense has had in relation to the pangolin. But if you check around the environment in Zambia, or rather, if you check around Zambia, you find that there's not so many experts to go around so many courts and deliver such impact statements, let alone to different other experts. So these are some of the challenges that are being faced. And also, these experts, even if you have one or two that are available, they will not have that experience to be in court and deliver an impact statement. So it would be like my colleague Diana put it, that we're in our infancy stage. So even if the expert is found, that expert will still need more capacity building to be able to understand what are the requirements in court and how should the statement come out in court. Not only that, you find that, like my colleague put it earlier, that we have mandatory sentences in the Wildlife Act. So if more victim impact statements could be presented to the court, it gives leeway for the sentences to be a bit on the harsher side. But if left like that, the statute already provides for what the minimum should be and what the maximum should be. So unless a victim impact statement is presented, then mostly it remains on the minimum side. Of course, there is a part during the trial process before the sentence is handed down where the court receives information about whether the offender is a second offender and whether there is anything that could be said in mitigation, that is in relation to both the state through the prosecutors and the offender. So it is at this point that the court receives information on how stiff the sentence should be. If the person is a second offender, definitely they'll receive a harsh sentence. So in this case, if the victim impact statement could be brought in, then it gives the adjudicator the leeway to extend the sentence beyond what the minimum would have been, because they have that basis of a victim impact statement which presents the aggravating factors as earlier stated. But safe to say that amongst the greatest challenge is the lack of understanding of what victim impact statements themselves are and how this can be presented before court. I think there's still a lot of capacity building that needs to be done, not only for the justice actors, but also for the experts that will be required to be brought in to deliver these victim impact statements. Thank you.
Thank you very much, Edward. That's very interesting. Ray's just given me a little hands up in the chat. Who wants to make a little response from his experience?
Yes, thanks very much, Edward. I think a lot of the difficulties that you experience in Zambia, we experience in South Africa, and I'm sure many other Southern African countries. On occasion, I have, as a species expert, presented to the court virtually, because often it's not possible to travel many miles to get to the court, or you've got prior arrangements. I'm not sure if the Zambian courts would allow you to have a species expert present virtually.
Okay, so the recently in the Zambian legal system, there's been acceptance of presentation of witness evidence through the use of technology, like you put it, like a Zoom call or a WhatsApp call, because after the COVID period passed, we saw a move towards accepting these methods. But sometimes the courts will have reservations on the security of the system. How do you incorporate that system into the judiciary system when that communication is being made to ensure that it is secure and that the person they are speaking to is indeed the person that they are speaking to and for the purpose of the case? So that's why the reservations have been in some courts. But with some courts, it has been okay. Briefly, just allow me to give an example of where we had recently been pushing for magistrates to allow disposal of pangolins, or rather the release of pangolins into the wild using video conferencing. So instead of taking a pangolin from miles away to the court because of that stress, so we pushed. So you find that the responses from the magistrates, others were more acceptable to that, but others had reservations because of technology and thinking it might be hacked in one way or another. So that, I hope, briefly answers your question a bit.
Thank you very much, both. It's a question that's come to mind. It's more for Ashley, actually. We were talking the other day about species victimization. I just wonder if you want to share some lessons you've learned in relation to environmental victimization in Southern Africa.
Absolutely. Thanks, Alistair. And I think the sentiment was raised by all of the speakers, actually, is that wildlife is not regarded as a victim. You had started in your introduction explaining that. And I think the sentiment has really been mirrored by all of the speakers. In South Africa, we don't actually have a legal definition of what a victim is or who a victim is. But we do have a law commission definition, so not a legislative definition, but more of a policy definition that defines a victim, and this is a direct statement, as a biological person who has suffered harm at the hands of another person in the course of a crime of violence. So I think what you can take from that is it's incredibly anthropocentric. It's very human focused, and in our view, far too narrow. One thing that Karina had raised in that scoping report that I'd mentioned in my first briefing is the interlinkages between victim impact statements or impact statements and the criminal justice system as a whole. What we've been talking about in this panel is the use of it in prosecutions, but there, at least in South Africa, there are other ways of achieving justice within the criminal justice system as a whole that don't require a prosecution. And that may be particularly relevant where you have wildlife crimes that are not linked to organized crime, but maybe more subsistence-based or as human-wildlife conflict that still require a justice process, but maybe not necessarily a formal prosecution. So we launched, in recognition of that, a project in 2019, also funded by the USAID, to explore a flexible and participatory and inclusive approach to justice. And one thing we had to grapple with is who is a victim of wildlife crime. And one thing that we did is we used a conceptual framework developed by Clifford Shearing and Julia Berg called harmscapes. And what one would look at then is a landscape of harm from a single event or a historical event. We chose a single event, and identify who is harmed by that event, and by virtue of who is harmed, who is the victim that should be participating in the relevant process. And what we found is that harm can be broken into three categories: harm to people, and that can be individuals or communities; harm to the environment, to the individual animals as well as the environment as a whole; and harm to society, both at a micro and macro level. And so to give you an example, and I'll use an example of a syndicated wildlife crime because I think that's where most people are familiar. So let's say we have an instance of rhino poaching. The harms that may occur in that, specifically in the South African landscape, is harm to individuals. So you may have an instance of use of deadly force where rangers are being shot at and need to defend themselves through that process. The mental impact of being involved in conflict situations, as well as, and we need to be realistic with at least the South African context, is trust. And the influences of corruption that we see within certain factions of our society. So I've mentioned harm to individuals and the personal impact. The financial impact, I think we're most familiar with, the costs of anti-poaching, the costs of vets, etc. But what we haven't really been engaging on is harm to communities. When we did quite extensive engagement with the communities in our project area, so these are communities bordering the Kruger National Park in Mpumalanga. And one thing that the community said is they're increasingly experiencing human-wildlife conflict because wildlife offenders are cutting the fences that South Africa uses as part of our protected areas, which results in more migration out of the protected areas. So we're seeing increases in human-wildlife conflict, which is causing increases in frustration between communities and reserves. We're also seeing increases in social ills that come with illicit money. So increases in prostitution, increases in illegal gambling, drug abuse, alcohol abuse, etc. But one thing that will, I think, stay with me for a very, very long time, if not forever, was one of the community leaders saying to me that you have no idea the impact of when everybody drives through your community and thinks you're a poacher, and what poaching is doing to the community fabric, and the harm that that's resulting in. Harm to individual animals, I think, represented very well through impact statements now, but also harm to the broader environment. So what happens if you have population declines, and the resultant impact on the broader environment that we're seeing, specifically where those species are keystone species. And then one aspect of harm that we really don't have an opportunity to engage on is the harm to the society as a whole. So what do wildlife crimes impact our heritage, or what is the impact of wildlife crimes on our heritage, for example, on our customary practices, on our culture, on our tourism? We've actually seen micro-tourism impacts where certain gates of the Kruger National Park are not favored because of organized crime. So all of the associated businesses linked to those specific gates don't have the same amount of support as the more popular ones. But then also to South Africa as a whole. So if you look at it, tourism from a macro approach, what does it mean when people are picking countries to travel to, and one country is known as more dangerous than another country? And these are all harms that have created very real victims within these landscapes. And I think if colleagues are interested in this field, this is something that my colleagues, Dr. Annette Hupschler and Mike Bately, have written up in a book called Environmental Restorative Justice, where we're starting to explore what complementary or alternative approaches to criminal justice could result in, and how flexible and dynamic we need to be in responding to a very flexible and dynamic illegal operation. And then also just one thing that I would like to raise is we tend to think about in the end of the justice process as somebody being convicted and sent to jail. A lesson from South Africa that I think is very relevant while we're engaging on what effective justice is that South Africa, across all of our crimes, has one of the highest rates of imprisonment globally. But we also have one of the highest rates of reoffense. It sits between 60 and 90%. So out of every 10 people we send to jail, between 6 and 9 of those individuals will come out of jail and commit the same crime again. So while we're exploring effective penalties, I think we do need to keep that in mind. And that's something we're exploring through this restorative justice project, is how do we respond effectively to harm, but how do we also respond effectively to prevent reoffense in the country?
Thank you very much, Ashley. Sorry, Diana, I don't know if you wanted to make a quick intervention from your experience with Zambia, or you okay? Oh.
Just to add to what Ashley said about the victims, the question of who the victim is. So in Zambia, the Zambia Wildlife Act actually provides an option for the court, in addition to the sentence, either it be a custodial sentence or a fine. The court can also order compensation, but then the act specifically says the compensation is to the government of Zambia. So then in this case, the question is the government the victim then? And the act also provides for an option for either the government of Zambia or a person. In this case, obviously, a company would qualify as a person to commence a civil suit to sue for compensation from the accused person for the injury or damage that has been caused by his actions. So I think it's still an issue of who is the victim in wildlife offenses and who then benefits from that. Once the compensation has been paid, does it benefit the communities around? If it's a national park, does it benefit the communities around that national park? Who benefits from that compensation? So it's yeah, I agree with you.
Alistair, if I could,
Please.
So South Africa's got a similar framework where, as part of our sentencing phase, we can recover civil damages that result from a criminal case. So we don't have to create or follow two separate legal processes. We can incorporate that civil damages claim as part of the sentencing. But I think it's inherently limited in that, how do you qualify harm to heritage, for example? What is the rand value on that? And then, like you correctly say, if you do have this lump sum of money, who does it go to? So something that we're proposing is once you've identified your victims, those victims should actually be central to the criminal justice process, and they should really be the guiding voice about what an appropriate outcome should be. But again, keeping in mind what I just said now about justice versus retribution, and finding a way that is true justice.
Sure. Thank you very much. There's been a few questions in the Q&A. If anyone wants to add to them, please type away or raise your hand, and we might be able to do it live, but that might be testing my technical ability. There's a few here. I'm just going to, the panelists have answered. I'm going to do them in reverse order, just to get the conversation a little bit back into Hong Kong territory. Amanda, there's a question from Kathleen. I'll read it out. You have given a response, but just to, I don't know if you want to build on it. Regarding the increase in the penalties in Hong Kong or elsewhere as a result of the use of the impact statements, could you please explain how this was measured and whether other possible reasons might have also contributed? Oh, you're on Amanda, sorry.
That's a very good question. Thank you for that question. And yes, of course, we don't take complete credit. We are part of an initiative to try to improve the reaction of legal professionals to wildlife crimes, so that they understand it better. Now, in Hong Kong, of course, penalties increased through legislative intervention at the same time as our initiative came into play. But that fed into our initiative. That was how we got access to the chances that we had to train legal professionals, because they were suddenly much more interested in the area. And the way we tested it is, I'm an academic, so I did it through research. So I took empirical data from sentencing before and after the Species Victim Impact Statement initiative started, and that's how we were able to track the changes that had occurred. I just wanted to go back, though, to something that Ashley and Diane said, and talk about this idea of expanding the notion of harm and what is harm. I mean, it's obvious that you can speak about individual animals, but obviously you must go well beyond that and think about the impact on social groups, the impact on ecosystems. And this is where I think it's important that you have scientists involved in the drafting of your species victim impact statements. And we've always had scientists at the core of ours, and I know that the other panelists here have as well. And the reason for that is that they think about things like the fact that if you take out a top predator, what happens to your ecosystem? Or if you take out the prey, what happens to those keystone species that are relying on those other species in order to survive in probably situations where already habitat degradation and other problems are causing them to be pushed towards extinction? So you need to think about those things. We also include invasive species risks when these species are smuggled across borders, because we use most of our species victim impact statements for wildlife trafficking cases. We talk about pathogen concerns and disease concerns that follow on from wildlife trafficking across borders. So there are other areas of harm that are easily overlooked unless you come to this with a scientific lens. And that's why I really do suggest that people do make use of the wonderful wildlife biologists and conservation biologists that are available and willing to use these kinds of mediums to help to achieve impact in this area. And one more point about what you include. Be very careful that you only include information that is reliable to a court, because you only get one go. If you show up to a court and you put in information that's not reliable, not verifiable, not admissible, then the court will lose confidence in the value of your species victim impact statement. So we don't, for example, use news reports as much as they may well be entirely reliable, because they're not peer-reviewed scientific research. You must be very careful what you include in a species victim impact statement for the sake of the credibility of that statement, and in order to get the court to take it seriously.
Thank you very much. Ashley, please.
Sure. I think just following on to what Amanda has said, and I think this again will vary from jurisdiction to jurisdiction about how you're using impact statements, but you may need to have more than one. So within South Africa, for example, they follow the form of an affidavit. So the information within that statement needs to be within the expert's personal knowledge. So you may not have an expert that can speak to all of these, but you can certainly bring more than one expert. So you can bring a social scientist or somebody like Ray, who's a species expert, and they can bring different impact statements that collectively would show the cumulative impact of the harm that is experienced from a wildlife crime.
Thank you very much. Just sort of sticking on the theme a bit about what to include in the statements, there's another question from Simone that's asking about whether there's a central database or library globally, saying that she recently met someone when she was in Brazil. They've been developing their own initiatives out there, and is there a way of sharing them? I noticed, Amanda and Ashley, you've responded to that, but I don't know if you want to just talk about if it is shareable and maybe the challenges that go around with sharing them as well. Whoever wants to go first.
Okay, I'll just quickly answer that. I wrote in the chat, we do share them. We share them only with legal professionals. We don't share them publicly because we're concerned that if we share some of the sensitive information involved, it may actually encourage poaching. We include black market value and such, and things that we would prefer that are not publicly available. So you need to be careful about that. But at the same time, there are a group of people. I mean, you can see the people here today that are all happy to work with others, and we'd all be delighted, I'm sure, to give input and suggestions for things that might be included, and to pass this information around, because we're all looking for resources. We're all looking for people that can help to make our impact statements better.
Yeah, maybe just as a follow-on to that, and I mean, I was guided here by Corinna's, like I said, she led this project, but we developed this for prosecutors to be part of the justice process. These are not tools that we've designed to share information with the general public, and I think the way you would approach general awareness raising versus specific tools for prosecutors are two different forms. So ours are specifically only available to prosecutors, and they've been shared with the over 100 prosecutors that we've worked with in the region. But in addition to our prosecutors, also some law enforcement agencies, and they would also be the kinds of individuals who would give expert testimony through impact statements or expert statements. So I think if there is a request, you are more than welcome to contact me directly, and we could consider that. But ours were developed specifically for prosecutors, with prosecutors and for prosecutors in Southern Africa.
Yeah. Thank you very much. We are approaching the top of the hour. There was one sort of remaining question from about how, well, it's just crops on my, oh, it's cleared. About Ross McCoon. I don't know if anyone wants to quickly answer that, the difficulties in well, his question there. Sorry, I just dropped off and my Q&A has just cleared. But if Amanda or Ashley, you want to quickly summarize what was that Q&A there, then we'll wrap up.
Sure. So what Ross had asked is whether one would, in the victim impact statement, consider all the laws that are broken. And again, I think this depends on jurisdiction to jurisdiction. So in South Africa, as Ray said, our statements are used in either aggravation or mitigation of sentence, generally from a species perspective in aggravation. So they come in at the sentencing phase, which means that the person has already been convicted of the charges that were put before them. So we already know the laws that are broken because he's already or she's already been found guilty of them. So it's not really relevant in our statements. Ours would focus more on the harm and what does the court need to consider in the identification of an appropriate sentence. I think in other jurisdictions, and Amanda can speak to this, it's used more as a tool for information, and that came through in jurisdictions like Botswana as well, where it's used actually at the prosecution stage, not the sentencing phase, in which case then the laws are very relevant. So I would go back to that lesson that Corinna had identified. Start with a scoping exercise of your jurisdiction and what do you need in your jurisdiction for an effective statement, and then be guided by international best practice.
Thank you very much. Pretty much bang on the top of the hour. It's very impressive. I would just want to say, wrap up, many thanks for everyone who's joined, from the panelists and everyone who's attended. It's been a very interesting conversation. So, and I would like to, and if anyone would like to continue this conversation with the panelists, I was trying to find a way of sharing my email. But if you'd like to get in contact, there is the Secretariat email on the Global Beneficence website. If you do just say it's in relation to species victim impact statements, it will find its way to me, and I will can see if I can put you in contact with one of the panelists as well. I think a very good tool or important thing about this initiative is that people are networked and do talk to each other, as been repeated, said many times on the call. So nothing much more than to say massive thank you. Enjoy the rest of your days, and hopefully speak to you all again very soon. Thank you.
Thank you all.
Thank you.
Thank you.